Today, we're digging into a story that isn't some high-stakes corporate drama or a massive constitutional crisis. Nope, this is a small story, pulled straight from a real administrative law case, all about a neighborhood dispute over a single vote. And it's a perfect cautionary tale about how the smallest details can end up having the biggest consequences.
And this is it. This is the sentence that kicked the whole thing off. Taken directly from the official petition, this is the core of the complaint. It's the spark that turns a simple neighborhood disagreement into a formal legal battle. One homeowner feels her vote was ignored, and she is determined to get it counted.
So let's set the scene here. You've got a really contentious recall election for a homeowners association board. Tensions are running high, right? Every single vote matters. And right in the middle of all this, one homeowner becomes convinced that her ballot was just unfairly tossed out and that it could have changed the entire outcome.
So who are the players here? Well, on one side, you have our petitioner, Bonnie Chancellor. She's the homeowner who feels she's been wronged. And on the other side, the respondent, the Carriage Parc Homeowners Association. That's the very organization that ran the election, and in her view, the one that discounted her vote. When you boil it all down, the dispute is actually pretty simple. Bonnie Chancellor's argument is basically, hey, my vote wasn't counted and it needs to be. The HOA's response is just as direct. Nope, the ballot was delivered after the meeting had already ended. It was too late. And this fundamental disagreement over timing is what escalates the whole thing to the next level.
Okay, so nobody's budging. This is no longer just a community issue that can be sorted out over the fence. Bonnie Chancellor takes the formal step of filing a petition. So now, the matter is officially out of the hands of the neighbors, and it's sitting in front of an administrative law judge.
Before the case even really gets off the ground, the judge makes a key ruling. Bonnie's husband, Dennis, gets removed from the petition. Why? Because he isn't technically a member of the HOA, so legally he lacks what's called standing. And this is our first clue that in this arena, the rules are going to be followed to the absolute letter.
All right, so with the parties officially established, the judge issues a formal order. This isn't a casual chat anymore. This document lays out the precise steps that both Bonnie Chancellor and the HOA have to follow to get ready for their day in court. Everybody now knows the rules of the game.
And right here, this is the moment where the entire case just pivots. And believe it or not, it has nothing to do with the vote, the HOA meeting, or who was right or wrong that day. It's all about a simple procedural step and a date on a calendar.
So what did this order say? Well, it was crystal clear. Both sides had to submit a list of their witnesses. They had to include a little summary of what each person was going to say. And here's the big one. It had to be filed by a firm deadline of May 16th, 2008. Oh, and they had to send a copy to each other. Seems straightforward, right?
So let's look at how this actually played out. On April 29th, the judge issues the order. May 16th, the deadline, it comes and it goes. Silence. Then on May 19th, the chancellors file their witness list, 3 days late. 3 days doesn't sound like a lot, does it? Well, in this context, it was absolutely everything. And boom, the hammer came down. The consequence was immediate and, honestly, pretty brutal. Because they failed to follow that order on time, the judge ruled that the chancellors were not allowed to present any witnesses at the hearing. Just like that, their entire chance to have people testify on their behalf, poof, it was gone.
In fact, the judge went even further. This quote from the decision says it all. The hearing itself, the one scheduled for June 4th, was vacated, canceled. The case would now be decided solely based upon the pleadings, which just means the initial written arguments that both sides had already filed.
So you can probably see where this is all going. With no hearing, no witnesses, the judge is left to make a very simple decision based entirely on the paper trail. The judge's logic was just methodical, step by step. First, he looked at the HOA's rule. Ballots were due by the end of the meeting. Check. Second, he reviewed the facts on record, which showed the chancellor ballot was in fact delivered after the meeting was over. Check. And therefore, his third and final step was simple. The HOA did the right thing. The late ballot shouldn't be counted.
And that's it. Case closed. The final verdict was just as blunt as the procedural mistake that caused it. Petition dismissed. After all that time and effort, the entire case was just thrown out.
But wait, the story isn't quite over yet. Because beyond just losing the case, there was a real, tangible, financial cost to this simple mistake.
$550. That was the filing fee Bonnie Chancellor paid just to start this case. And because she was not the prevailing party, she wasn't entitled to get any of it back. That missed deadline came with a pretty specific price tag.
So, what's the big takeaway from all this?
It's that in any kind of formal dispute, procedure isn't just a guideline or a friendly suggestion. Following the rules, hitting those deadlines, that can be the whole ballgame. You could have the best argument in the world, but if you stumble on the process, you might not even get a chance to make it. Which leaves us with a final question to think about. We'll never actually know if that one vote would have changed the election, will we? The case never even got that far. So I'll leave you with this. What do you think this story is really about? Is it an injustice over a ballot box? Or is it just a very expensive lesson about paying attention to deadlines?